Appeals Division 1 is now in session.
Morning. Please be seated. All right, this is the time set for oral argument in Genovese against Bodynew, our cause number 1CA-CV 16-0296. Counsel, I know you're aware that we have reviewed the briefs, conferenced the case, and you can bear that in mind as you begin your presentations. We will be audio and video recorded today, and those recordings will be made available online to the public. Each side has 20 minutes for oral argument, and the appellant may reserve as much time as you wish, subject to watching your own clock. So if you're prepared to proceed, we're ready.
May it please the court, counsel. There are two reasons why the trial court erred, and this court should reverse the trial court's decision in this case. The first is that Dr. Borsand has clearly held himself out as practicing in the field of plastic surgery, which was decided in the Lowe versus Lee case and in the Baker case. And so for that reason, we don't need to even address anything else realistically in this case. He's held himself out as practicing as a plastic surgeon. Therefore, the appropriate expert would be a plastic surgeon. The second reason, of course, is that the statute that regulates experts practicing and providing testimony in courts was clearly met by Dr. Chow. He complied with every aspect of that in being board certified to do cosmetic and reconstructive procedures.
I'm obviously going to ask your colleague on the other side this question, but is there a difference between the two disciplines?
Well, there is no case in Arizona that discusses that. There's no case in Arizona that actually discusses where the short answer is no. There's not really a difference in the aspect of...
Leaving case law aside,
sure.
Is there a substantive medical difference between plastic and cosmetic surgery?
Yes, there is to some extent.
Okay,
the differences are this. The expertise or specialty of plastic surgery includes cosmetic and reconstructive procedures. That's what people are board certified as, and when they're called plastic surgeons. A cosmetic surgeon is presumably certified by the Cosmetic Surgery Board to do cosmetic procedures. And so, for example, a breast implant or a tummy tuck, some people might refer to the tummy tuck as being a reconstructive procedure, but those type of procedures are generally considered aesthetic or cosmetic. Burns, those things that deal with more complex issues.
But is there any medical difference between cosmetic and plastic surgery?
No difference in terms of what the standard of care should be medically. No, there is no difference. In fact, somebody who's doing a breast implant procedure, or liposuction, or abdominoplasty, whether they're a plastic surgeon, consider themselves the one, or a cosmetic surgeon, they sure as heck better be adhering to exactly the same standard of care.
Different level of expertise required.
Well, I think that's arguable, depending on who you ask. If you were to ask an MD plastic surgeon, they would say that their training is more comprehensive and that they are better trained than a DO who becomes a cosmetic surgeon. If you ask a cosmetic surgeon that question, they'll give you the exact opposite answer. The truth is that these boards can be, to some extent, self-creating, which is part of the concern and the problem here. We have a plastic surgery board that has decided that we are going to certify doctors in cosmetic and reconstructive procedures. We have another board that said we're going to carve out one part of that and certify people for just that one part. And there's a real danger in doing that, and you don't have to look a whole lot further than even in this case. The danger is what happens when we have a board-certified dermatologist. And then some board group of doctors get together and they want to form the Board of Acne Medicine. Now, clearly dermatologists deal with acne. It's part of what they were certified to do. Yet, using the defendant's argument here, somebody who is a dermatologist, board certified by the American Board of Dermatology to treat people with acne, would have to go get certified by another board for acne medicine in order to be qualified under the defendant's view of the statute.
Who sanctions these boards?
Who sanctions them? Well, that's a good question. It's not part of the record, but you've asked. The American Board of Cosmetic Surgery is not certified by the American Osteopathic Association. Regrettably, it's a fact that didn't come to light until I happened to Google it last night. But they're not. So
I'm reluctant to tread too far into what Google has to say, but the hypothetical would be if 6 doctors get together in Scottsdale and decide to form the board of thoracic cosmetic surgery and incorporated a nonprofit to do so. Would that be, with no authority, no connection to any other organization, government or otherwise, would that be any different than the Board of Cosmetic Surgery?
No, it would not.
Okay.
And the answer is there is within the 2 medical specialties, MD-DO boards, there are requirements that certification processes be through there's an accredited certification group, which the Cosmetic Surgery Board is not a part of, has not been accredited by.
That part in the record?
No, it's, well, it may be in.
The assertion that they are not accredited, is that in the record?
I don't think it is, but it may be a part of the description in the motion where we just put forth the information from the Plastic Surgery Board. It may be in there. It slips my mind whether it's included.
When you start talking about the osteopathic board and the medical board, now you're talking about the state medical board and the state osteopathic board.
Yes, Your Honor.
Right, but they don't, the medical board and the osteopathic board don't say, gee, to hold yourself out as a plastic surgeon or a cosmetic surgeon, you have to be a member of some other board, recognized by some other board. Only if you say, and correct me if I'm wrong on this, only if you say, I am board certified.
You have to be board
Have to be board
certified
certified.
by a board.
By a
Right,
board.
correct.
Okay.
Are
And
there alternate boards?
there are.
So if I wanted to be certified as an orthopedic surgeon, do I have my choice of boards I can go to?
Well, there's the American Board of Orthopedic Surgery. I think there is another board. The osteopathic board has a certification in orthopedics as a specialty, but there's no similar for cosmetic surgery. It doesn't exist.
I just chose orthopedic out of a hat. My point is that there's no legal underpinning for any of these boards to have the exclusive ability to certify in any specialty or subspecialty.
I would agree, Your Honor, and that presents the biggest problem and challenge with this case, because we are now dealing with somebody who is in fact board certified by a well-recognized board to do the very procedures in issue in this case.
So you're talking about
Dr. Chow. Yes, Your Honor. You then have Dr. Borsan, who is board certified by another board, and I'll grant you, I don't think the cases to this point have described whether there is some analysis that has to be done on the certification process itself. They have to be comparable. I think Baker says that, and that's pretty clear. But in terms of, go ahead, I'm sorry, Your Honor.
But let me just make something clear, because I remember reading something in Baker. There is an American Board of Medical Specialties,
Yes, Your Honor.
right? And it recognizes both cosmetic surgery and plastic surgery, right?
Well, the American Board of Medical Specialty has the certification for plastic surgery, and it describes in its material, which is part of the record and was submitted to the judge.
Right. But the American Board of Medical Specialties is sort of an umbrella, is that right?
It is.
And it recognizes the American Board of Plastic Surgery.
Correct.
Does it also recognize the American Board of Cosmetic Surgery?
No, it does not.
Okay.
It does not. And so the Baker case, I think, made very clear that in terms of interpreting this statute, we don't need to have people certified by these same boards, and we're not suggesting that's the case here. We're suggesting that the whole purpose of this statute was to ensure that comparably trained people come in and testify against other people in the same field.
That's a nice way of thinking of what the legislature was up to.
Well, I think clearly it's been stated in case law.
I know, in case law, I said, yeah.
Sure.
Yeah.
So I don't have a witness here from the legislature, but if I did, I suspect
I think
that's a logical
there's
common
authority
sense.
to support what
Sure,
you just
sure, and that's a common sense reading. As a practitioner for 30 years, honestly, I don't know why someone would bring a cardiologist in to testify against a vascular surgeon or something, but so be it. That's the law.
Well, this usually comes up in cases involving subspecialties.
That's correct.
Which is why my question really was whether cosmetic surgery is a subspecialty of plastic surgery or whether it's simply a label describing, one's concern with more subjectively aesthetic results
It is clearly a label, Your Honor. There is no subspecialty that someone who is board certified by the American Board of Plastic Surgeons, there is no subspecialty in cosmetic surgery that they get. Their certification is a certification for cosmetic and reconstructive procedures.
Did you create a subspecialty by requiring, say, 10 additional years of experience? Would that change your analysis at all? If you say, in order to be certified in cosmetic surgery, you need 10 years of experience doing cosmetic surgery.
And the other board doesn't require that?
The other board does not require that.
Your Honor, in our view, and I think the case law clearly supports this, the training just needs to be comparable. There's no wording in the statute that says that they need to be board certified by comparable boards with comparable training and comparable experience. It just says to be board certified. And if we look at what board has been around for 90 plus years, it's the American Board of Medical Specialties, and they've certified him as a plastic surgeon, Dr. Chow, and they've been around for almost 100 years. So to suggest that there is the ability to create another board and carve out a portion of what somebody's already certified to do would frustrate the statute. I mean, it would be so unjust for Ms. Genovese to not have a plastic surgeon come in for lots of reasons, not the least of which is Dr. Borsan disseminated all over the world that he's a plastic surgeon doing plastic surgery and defined these very procedures as plastic surgery.
But he did say, I'm a cosmetic surgeon.
He did both. It's on his website, both.
Yeah.
It's
But
both.
the website is less compelling, though, isn't it? Because he could have simply called them surgical procedures. And just bringing in a general surgeon, I'm sure you concede, would not be good enough.
I would agree with that.
So whether he lifts the description to a higher level of abstraction doesn't really resolve the question, does it?
Well, I think it does in part. If he was saying that he was providing, doing the following surgeries, well, he's a board-certified cosmetic surgeon. Those are surgeries. I think that's perfectly reasonable. The reason that cosmetic surgeons do that and try to confuse the issue is for the very reason that they want people in the community to just think they're the same. And maybe they are. The training, as I said, if you ask both sides, you're going to get a different answer. But this is not a situation where there is a distinct subspecialty that has its own separate treatment. For example, if you look at the cases that have been cited, the cases where there is a pediatric hematologist and somebody is a pediatric oncologist or an internal medicine doctor and a cardiologist. One of the cases describes the fact that people don't ordinarily go to their internal medicine doc for chest pains. Now, the doc might treat that or deal with it if it happens to show up in their practice. It's not what they normally do. Similarly, a cardiologist isn't dealing with urinary tract infections. And so they're very different, and there are certifications for them.
If the cardiologist, somebody came in to cardiologist for, let's say, an EKG, and said, gee, I've got this pain in my bladder. And the cardiologist said, I can give you something for that. He wouldn't be required, the plaintiff wouldn't be required to bring a cardiologist to testify about whether that was appropriate, would he?
Well, it's interesting. That has come up once or twice in my practice, and it's concerning. And this statute is problematic for that.
If you practice outside, if you're a certified cardiologist, but what you do, the procedure you do, is outside of cardiology, it seems to me you could bring somebody else who is trained to do that.
And that has come up in a couple of the cases we've cited from the court.
So the Board of Plastic Surgeons, it doesn't say cosmetic surgery is a subspecialty.
Correct. It does not specifically. It is not, and it does not say that, and it is not a subspecialty.
But you would agree that subspecialties, for example, say you're a board-certified cardiologist, that doesn't give you the ability to submit an affidavit against a board-certified interventional cardiologist. You would agree that there can be subspecialties within these disciplines that matter.
Absolutely, and there are. There are many fields that have that. Plastic surgery is not one of them. And so we have to look, and I think the statute really wants us all to look at what is the treatment, what is going on. And there is a case that describes that theory. We want to look at what is being done here because we want to serve justice. The overarching purpose here is to bring people in front of a jury that can meaningfully describe the standard of care and meaningfully help the jury and assist the fact finders. We have people in this case doing literally the exact same procedures day in and day out in their practice. There's no dispute about that. And just by naming themselves, a board names themselves one way or another, isn't the test, and it shouldn't be the test. For example, the American Board of Plastic Surgery could very, very easily tomorrow, if they wanted to, change their name to the American Board of Plastic and Cosmetic Surgery. Nobody'd have to get certified differently because they're already certified for that. Would we now have a different issue? Would Dr. Borsan's counsel say, well, I guess they're board certified in plastic and cosmetic surgery because they put that in their name? I mean, that's what Baker and the other cases discuss. We're not going to make these decisions based on a name or a moniker that some group wants to use. We have to look past that, and we have to look and see what do these folks do in their daily lives. And if they're doing the same things and they're both board certified to do those things.
They're doing the same things, but one certification does require additional experience.
Well, it depends on who you ask on what that additional experience is. You can't get into the plastic surgery board without having plastic surgery residency and fellowship training.
But
that's different in the cosmetic board.
Isn't there a requirement for the cosmetic surgery certification that there be more hours of cosmetic surgery procedures than for a board certification for plastic surgery?
It does, but there's a reason for that, because the cosmetic board is only certifying a portion of what the plastic surgery board is certifying. So, a person only has so many hours in their life to do so many things to complete a project. If someone is asked to do one thing and someone is asked to, to cover 5 areas, you're gonna have slightly different certification or slightly different training.
But that kind of plays into the subspecialty argument, doesn't it?
No, it doesn't, because it's not. The statute doesn't require that they have identical training, because we all know that the DO at the Des Moines School of Osteopathic Medicine is not getting the same training as the MD at Stanford is, the same education. For if they were, everyone would just go to that school. So we know there's differences. Those differences go to the weight. In other words, if the statute doesn't say board certified with the same training and the same rigors of the certification process. Your question, Your Honor, respectfully, would go to the weight. They would presumably put Dr. Chow on the stand and say, isn't it true, sir, that you only had to do 150 hours as opposed to 200 or 300 or whatever the other it requires? Try to paint him as not as qualified. But the statute doesn't require that. And it certainly wouldn't want to bog the court down, a trial court, with having to make judgments on whether somebody's training is the same or materially different. It's not materially different here. And these folks are board certified to go out and do these exact same procedures, and that's all the statute requires.
What bogs the court down, though, is having to make that comparison, as opposed to you went to someone who's certified by this board. Why not go get an expert who's certified by that same board to explain why?
Well, because of the very problem one of the other justices raised, and it happened in this particular case. If you get a couple of docs, or 20 or 30 or even 100 of them, to carve out acne medicine or retin-A medicine or biopsy medicine or something that people are certified to do within their own specialty, you can't get an expert. We went through 50 people trying to find somebody that was certified by the American Board of Cosmetic Surgery to testify against Dr. Borsan, and because he is so well known in that organization, no one would even review the case. And so we had that problem, and you can see that the very thing that is the fear here was tried by Dr. Borsan here. He not only said that he wanted somebody to be an expert certified by the the Cosmetic Board, but he also wanted them to be a member of the Academy of Cosmetic Surgery. It's a trade organization. Now, of course, the trial court said, no, you can't require a plaintiff to do something more than the statute requires. But there's the fringe. There's the start. And we can't, as a society, have people carving out little portions of medicine and using the statute to prohibit people from providing expert testimony for which they are eminently, perfectly qualified to do. I see I only have about a minute left, and I wanted to save some time for rebuttal. But if there are no other questions.
Thanks.
Okay.
Good morning, Your Honor. Your Honor's Eileen Gilbride for the defense. Counsel makes an interesting argument that would be interesting to the legislature, but it doesn't belong here. Before I get to that argument, though I want to say a word about the standard of review. It is abuse of discretion. It's not de novo, because we're not talking about interpretation of the statute. We're talking about whether Dr. Chow factually does or does not meet the qualifications.
So have to talk about interpretation of the statute? I mean, don't we need to know whether the statute really reaches to certification by particular boards?
Not at all, because I think the Supreme Court already took care of that in Baker versus University Physicians. It said we're not going to limit ourselves to the ABMS boards. We're going to open it up. Specialty means if you're able to be certified by a board. And
By any board. So, I mean,
Well,
the plaintiff's
let's-
bar might do well then to game the statute by
Who might do
creating
well? I'm sorry?
The plaintiff's bar might do well to game the statute by just creating a bunch of different boards and having one doctor certified by all of them. That doctor could do all the preliminary affidavits.
Well, let's put it this way. If plaintiff had argued in this case that Dr. Borsan really wasn't board certified by a board that mattered, that was a legitimate board, I suppose we could have responded and brought forth evidence that the board, that the cosmetic board, is a legitimate board. He never made that argument below.
I'm not suggesting that the cosmetic board isn't a legitimate board, but I do think that there is some statutory interpretation involved here, because under my somewhat absurd hypothetical of creating all these sham boards, it seems that the reading of the statute we're operating under in this discussion would support that.
I don't think we even have to get there in this case, because there's no question that the Board of Cosmetic Surgeons is a board. It's been around for 30 years. He was certified under it. It requires, if you look at our brief, our answering brief, it requires all these extra steps that the Plastic Surgery Board.
The extra steps beyond additional experience, are there, does it require different types of procedures to be utilized?
The training and the qualifications are different. First of all, to even apply for the Cosmetic Surgery Board, you already have to be board certified in another board, or you can't even be board certified as a cosmetic surgeon. You must have already graduated. Well, before applying for a cosmetic surgery fellowship, the candidate must already have graduated from an accredited medical school program, MD or DO.
This is just going, though, to more experience. Is it
It's
something more than...
it's more training, more experience and training, because they have to go through, again, 300 cosmetic procedures in order to qualify. They have to.
Okay,
It's on page 2 of our
What's the
brief.
difference between plastic and cosmetic?
You know, I think the real, I don't want to not answer your question.
Good.
Plastic is reconstructive, cosmetic is not reconstructive. But the real question here is, what's the difference? Is there a difference in the certifications? Not is there a difference in what we call the procedure? The statute.
Well, but I work with me for a second.
Yes.
Is the real difference then that plastic surgery is medically necessary and cosmetic surgery is not?
I've not seen it described that way, but to a lay person a non-doctor, I suppose you could describe it. Plastic surgery is reconstructive. Cosmetic surgery is aesthetic.
Okay. So if they're the same things, just motivated by different needs, then haven't we boiled it down? You can say that the Board of Cosmetic Surgery has more stringent certification requirements, but they're more stringent certification requirements for the same thing. So if we have a doctor certified by a lenient board and a doctor certified by a strict board, does the statute distinguish between those?
Yeah, and that's exactly why you want an expert.
Where in the statute
does it do that?
It says, if a party against whom or on whose behalf testimony is offered is or claims to be a specialist who is board certified, the expert witness shall be a specialist who is board certified in that specialty. In that specialty. The same specialty as the defendant. Not it.
Medically unnecessary procedures? I don't think
We
the
don't
statute
care.
was getting to the motivation for the procedure. I think
Right.
the specialty is what kind of medicine can you practice, not why are you getting the procedure done.
Right, and it's a specialist who is board certified in that specialty. It's so, and we know from Baker, from Preston versus Amadei, it doesn't matter if a cardiologist could do, or a general surgeon could do this. You don't have a general surgeon if you're a board-certified specialist.
What if a board emerges, the Board of Aesthetic Surgery? And it's exactly the same procedures that plastic surgery and cosmetic surgery involve, and it requires 2,000 procedures before you can be a certified aesthetic surgeon. Is that then a subspecialty, just because somebody called it that?
It may be. Well, you don't have to deal with that in this particular case because we have a board that has certified Dr. Borsan. This is undisputed. It's also undisputed, by the way. The real issue here is
You have a board that certified their proposed expert in a field that does the exact same procedure.
but just because orthopedics and neurologists or orthopedic neurologists can do the same procedure, it doesn't matter. It doesn't matter that they're able to do the same procedure. What matters is what their background and training was.
I think what matters is whether the procedures we're talking about are identical, not whether you could have a cardiologist come in and do a nose job.
Well, that's not what the statute says. The statute doesn't say we only care if the procedures are identical. It says you have to be a specialist who is board certified in that specialty.
But not certified by the same board. It just says the same specialty. What it says is
Right, okay.
It says, and I'm not putting words in your mouth.
I get
didn't
it. I know where
but
you're going.
The expert witness shall be a specialist who is board certified in that specialty. So then what do you do? And this gets back to the statutory construction. When you have a board of cosmetic surgery and a board of plastic surgery, and plastic surgery says, and this includes cosmetic surgery. Then what do you do? How do you, and that's why we need a finer scalpel, if you'll pardon the pun, on this, of what's the difference between, on these procedures, what is the difference between cosmetic versus plastic?
You go back to Baker, which says we're not going to limit ourselves to the ABMS specialties. We are going to allow specialist means any specialty in which you can be board certified.
Right.
And here he was board certified.
But then what do you do when the expert witness is board certified by a board that says this includes plastic and cosmetic surgery?
But it doesn't, he's not certified, board certified in the same specialty. And in this case.
Could I go back to Judge Swan's hypo with if someone just wants to create a new board that just requires 20,000 hours of experience, but there's absolutely nothing else different. It's just the level of experience.
And the new name.
And with a different name.
Do
you have to have an expert from this new group with the new name?
If a plaintiff wants to come in and argue and say, that's not a legitimate board specialty, my expert doesn't have to be board certified in that because it's not legitimate, it's not different.
If everybody agrees that they're the exact same procedures, the exact same qualifications, other than number of hours of experience.
That's not the only difference, though.
That's the hypothetical.
Okay.
If that's the only difference,
Okay.
is just hours of experience, and they've
Okay.
created a new board with a new name. You have to have an expert that meets that's board certified by this new board.
Or in the new name.
Well, we're not just talking about new names here. I mean, I suppose in that.
Doesn't it just go to the weight that you would give? This person has more expertise because they have whatever additional experience necessary for this newly named board?
Not if you follow the language of the statute as interpreted by Baker, is the man or the expert has to be a specialist board certified in that specialty, and that specialty means any area in which you can become board certified, and here you can become board certified.
But what is a specialty? A specialty is either the name or the substance of the medicine involved. And do we really care what the name is? I came up with a pretty good name, I thought. Aesthetic surgery is just as good as plastic or cosmetic. And we could probably get out a thesaurus and come up with a bunch of other names. That shouldn't require a different certification under the statute, should it? If we just change the name?
Well, if in a different situation that's not this situation, if you're changing the name, then the plaintiff can come in and say, that's not.
It kind of is this situation, because if we agree that the only difference between plastic and cosmetic surgery is medical necessity, that has nothing to do with what a doctor is actually trained to do or doing. It only has to do with the patient's motivation,
But
which
it doesn't
we don't care about.
just because two physicians in different specialties can do the same procedure. We have Baker that says that. Just because two physicians can do the procedure doesn't mean that that one is an appropriate expert for the other.
I recognize that, but our analysis is on a slightly different point here. The question is not, can you get a really great cardiologist who has a sideline? No, that's not
Right.
the question. The question is, if a doctor has lots and lots of training in cosmetic surgery, and that doctor elects to be certified in plastic surgery, cosmetic surgery, or aesthetic surgery, does that choice of name matter? Same doctor who's choosing which board should I go to.
It's not just a choice of name. It is the extra training. It's the year-long fellowship that plastic surgeons don't have to do. It's all of the extra training that's involved, which is why you want an expert with the same training as the defendant, so that we're comparing apples and apples.
But putting aside the training for a second, that's a fair comment, but putting aside the training for a second, I'm still confused about it. What the record shows is the difference between plastic surgery and cosmetic surgery, because you've got one board that says we certify cosmetic surgeons.
Right.
You've got another board that says we certify plastic and cosmetic surgeons. Labels.
No, they don't certify cosmetic surgeons.
Well,
they
but
only
said
certify
right, it's
plastic.
plastic surgeons, but it includes cosmetic surgery.
Some portion of their training involves that, but it's not.
But besides the training and besides the labels, as far as as Judge Schwan, I think you did sort of concede this, but I want to make sure what the record shows, that the difference between, in this context, the difference between substance, plastic surgery, cosmetic surgery, is medically necessary and not medically necessary. Is that
I don't
fair?
think that's accurate. I mean, certainly the record.
Right, tell us what it is.
The record doesn't say that. What the
what
record
does it?
says is the difference is plastic is reconstructive and cosmetic is aesthetic. And that's, I'm not a doctor either. But
to me,
I think what is important in this case is, was Dr. Borsand acting when he was doing his procedures here within his board-certified specialty? Certainly he was. We have a tummy tuck, breast augmentation, liposuction. Those are aesthetic. And he was acting within his board certification.
in all fairness, his own, it's not determinative, but his own website also described those as plastic surgeries.
But he held himself out, described himself
As
as
a cosmetic surgeon.
cosmetic surgeon. And that's what the statute requires.
Cosmetic surgeon performing plastic surgery.
No, he's performing cosmetic surgery.
Well, his website
even if,
says plastic.
well, let's say there are 2 or 3 mentions of plastic surgery on his website. That doesn't mean he's held himself out. But even if, let's just go with your hypothetical, and even if he was performing plastic surgery, just like a cardiologist or a general surgeon can perform, cardiology surgery or whatever, the statute requires someone with board certification in the same specialty, which means he has to have the same training, he has to have passed the same tests.
No, it doesn't. No, because different boards can require different levels of training.
Right, that's why you need someone who was certified by the same board as the defendant.
That's not what the statute says.
But the cases don't say it has to be the same board.
Is there any case that says you have to be certified by the same board as the defendant doctor?
It says you have to be board certified in that specialty. And specialty is defined by the Supreme Court in Baker as any area in which you can become board certified, and you can become board certified in cosmetic surgery.
What if there's a small island nation that has a board that certifies people in cosmetic surgery after watching a 3-hour YouTube video? And you get certified by this board. Is that good enough?
For here?
Yeah.
I suppose if the defendant was certified.
The same training, right?
If the defendant was certified by that board, yes, it's fine. But if the defendant was certified in
really good board,
something else that they called cosmetic surgery, that you have to have the year-long fellowship and all of the other training that's in our brief. No, that wouldn't do.
But it does get back to your argument, as I understand it. It's a fair argument, is that you have to be certified in the same specialty. And the problem really here, the nub here is that you've got a board of cosmetic surgery saying we certify cosmetic surgeons. Got a plastic surgery that says we do plastic surgeons, but that includes cosmetic surgery. And
Right.
so what do you do then as far as what the specialty is? And that's what the nub of this is.
The specialty is
Because
any area that you can become board certified in, and
he got
Isn't
board
this board,
certified.
isn't it a subset? Can a board certify someone in a broader category? So you have a narrow certification. If we assume plastic surgery is cosmetic surgery plus something else, is your certification as a plastic surgeon, doesn't that encompass the subset of cosmetic surgery?
it doesn't, because the cosmetic surgeon has had all this additional training and the extra training, the extra hours, the extra procedures, the fellowship.
But it's just the number of hours, essentially, is what I'm
No,
hearing. I'm not hearing a lot of difference between.
It's a year-long fellowship that Dr. Chow didn't have. It's 300 procedures that Dr. Chow
That's
didn't
just
have.
experience level. It doesn't suggest that there's different practices that either certification board would expect of the doctors that they're certifying. It's just the number of hours of experience. Is that fair?
Plaintiff hasn't brought forward any evidence that there's a difference in that. The reason Dr. Chow does the same exact, he hasn't brought forward any evidence to support that argument, that it's just that there is no difference in the actual procedures. And it's the statute, it's a language of the statute that we're talking about. It's the statute. Plaintiff might say, my guy walks on water. Of course he should be able to testify, but the statute doesn't say people who walk on water can testify because they're really, really good.
Right, but we keep getting back to, and you're right, that's what the statute says, is claims in the specialty. But I keep getting back to, I think we all want to say, what's the substance? Not the label, but what's the substance?
Right.
And so I'm asking, we keep asking, and I think the answer now is the only difference between, in this context, plastic surgery and cosmetic surgery. But it's not the training. I'm not talking about the training right now, but as far as a definitional, the concept of the substance of what was being done is that cosmetic surgery would be aesthetic and plastic surgeon would be reconstructive.
That's what the record says.
Okay.
That's what's in the record. That's
Okay.
what's in the record. And
Could
if the
reconstructive
statute,
could reconstructive include aesthetic?
aesthetic,
One would hope.
I'm sure, I would hope that whatever you're reconstructing would be aesthetically pleasing.
That's why it seems like the aesthetic aspect is a subset of
If
the reconstruct.
if you want to call it a subset, it's capable of being board certified, and that's what Baker interprets the statute to say. If it's a specialty capable of being board certified, then the expert has to have the same certification in that specialty as the
So
defendant.
let's say it's a subset. Is it part of the statute that the subset be medically relevant? Because we could come up with a bunch of medically irrelevant subsets that I don't know that the statute would command us to observe.
I'm not sure in a different context. I know in this context, we have a perfectly legitimate board. We've had Dr. Borsand, who has all of this extra training and expertise that Dr. Chow doesn't have. Maybe they can do the same sewing up and they can do the same scalpel, but that's not what the statute goes on. As Judge Katani said before, we're not concerned about whether two different doctors can do the same procedure. What justifies the expert testimony is whether they're board certified in the same specialty as the defendant doctor, and Dr. Chow isn't.
But not necessarily by the same board, because that's not what Baker says. It just says
Well,
it's
if-
a specialty.
I suppose if the Board of Plastic Surgery created a new, certification in cosmetic surgery that had, comparable things, then maybe that would be okay. But that's not this.
My problem with your argument and we've been sort of shunting it aside, about the number of hours of training is, it's sort of a slippery slope. Where do you draw the line? In other words, is there a rule of law that we could establish that said if you have 8 hours of training in this type of surgery, 800 hours versus 1,000 hours, that makes a difference?
We don't have
and
to.
And the issue there goes, if you've got basically the same training, maybe somebody has more because they had to go through a fellowship, and the other one didn't, but they're trained in the same procedure. Does that go more to the weight of what you're going to argue before the jury?
No, because that goes back to the fact that two differently certified or non-certified physicians can do the same procedure doesn't mean that they meet the requirements of the statute. You still have to be board certified in the same specialty as the defendant. Doesn't matter if they can, a general surgeon can do the same procedure as a board certified surgeon. That's not an appropriate expert, so he's not here.
But the unique problem here is the only difference between the two is reconstructive versus, as I understand it, your position is the only difference between the two is reconstructive versus aesthetic, and reconstructive would presumably include aesthetic, make sure it would be aesthetic.
No, my argument is that the type of procedure doesn't matter under the statute. It's the type of specialty training that matters under the statute.
Understood. Okay, thank you.
I'll be brief since I only have 1 minute and 43 seconds to do anything. Respectfully, Your Honor, what I've heard for 20 minutes now is that we would have to accept the definition that one board administers to their certified students over another board's definition. The Plastic Surgery Board does not define its certification process as being only reconstructive. It defines it as being cosmetic, is a part of the reconstructive procedures. These people are certified to do both. And it's the old Venn diagram that we had when we were younger. It's the big circle is plastic surgery, which includes reconstructive and cosmetic. They're certified to do those. And then inside that, we have the small section pulled out of cosmetic surgery.
That was a Euler diagram, but go ahead.
I thought it was a Venn diagram. Maybe not.
Venn diagrams are overlap, isn't it?
I'm in the minority.
It doesn't matter. Secondly, let's not misunderstand something. Dr. Chow was fellowship trained. The American Board of Plastic Surgery, which requires 2 years of fellowship training before you even get into their program. The other does it while you're in the program. So that
If there was a board that would issue a certification in 3 different areas that are not as closely related as cosmetic and plastic, if any board we could just get together and we're going to have a board and we're going to certify in 3 different specialties, would that count? Would that satisfy the statute? It is a certification, and we issue a certification. You can do 5 different specialties.
Sure. I think the Baker case addressed that issue, and we want to look and see what the people do in the majority of their time, and that's what the statute requires, that they spend a majority of their time doing. So I suspect if there was somebody who was spread so thin, in your example, that there might be a need to do that. But here, it's the exact opposite of that. I mean, we have a specialty that not only defines the words cosmetic surgery as part of what they do, it's the obvious common sense thing of what they have to do. If any woman has a reconstructive procedure and doesn't get some aesthetically pleasing result from that, the doctor's going to hear about it, and probably, we lawyers will as well. At the end of the day, if you're gonna look at what a specialty is, there ought to be some view of what are these folks doing, what are they certified to do, and in this case, it's not a close question. They're both doing the same procedures, they're both board certified, and that's all the statute requires us to look at. So I'm out of time. I'm happy to answer any other questions. But
all right. Thank you very much.
Thank you very much.
Both counsel for a very engaging argument. This matter is now under advisement. We will issue a written decision in due course, and we will stand in recess to allow the next case to set up.